procedure, and the bar would likely not have had the opportunity to conduct discovery, then it would be unfair to the litigants to require them to make a summary judgment standard of evidence showing that a foreclosure judgment shouldn't be granted.
Okay, thank you very much. We appreciate your presentation and all the additional information you provided. Okay, next we're going to hear from Alan Fields. And while he's getting set there, members, we have 10 more presenters from the public on this. The last one we just finished with Ms. Newton and the questions that were asked. We were up at over 13 minutes on that one presenter. Time flies when you're having fun, right? But I just want to mention to you that we had to be allocated that much to everyone who remains. We did not scheduled to finish our work today. So with that, Mr. Fields, you're recognized.
Thank you, Mr. Chair. I'm here on behalf of the Florida Land Title Association. I had planned to wait and support, but some comments were made suggesting improprieties on the part of my industry, and that concerns me. I want to address specifically the finality provision. There is without a doubt been a lot of fraud in foreclosure. We find people $25 billion in one case, 10 in another. The frauds were widespread. The trouble from the title examination standpoint is I know there was a lot of fraud. I just don't know which properties were affected. And no matter how carefully I review the court file, I can't tell. I can't tell if that's a legitimate signature or an authorized person. After the foreclosure is completed, I don't have authority to take discovery to figure it out. So the question really boils down to two issues. If you were looking at buying a foreclosed property and it was a great deal, would you buy it knowing that under current law there's the potential somebody can come back and take it away from you? And I submit the answer should be no. It's bad investment. It's a high-risk proposition knowing how much fraud has been out there. The second question is, at what point should these become final? The standard of this bill, as was pointed out a moment ago, is the person was properly served. They've had their day in court and lost. They had the opportunity to appeal and perhaps lost again. And the property's been sold to an innocent purchaser unrelated to either the former homeowner, who was concerned about some fraud potential, or to the lender or the servicing company. So the hard issue is, where should that judgment become final and unassailable? How long does that property need to sit empty before somebody can say goodbye? I'd love to be able to identify which files, which properties were tainted with the fraud. That would be the best of all worlds, but we haven't been able to come up with a way to do that practically or at all, quite candidly. And commerce and real estate needs to go on. I'm happy to take questions, but I thank you for the opportunity.
Thank you, Mr. Fields. Appreciate that. Well, next we'll hear from Ms. Deborah Lilly. Ms. Lilly.
Thank you for having me here. I grew up in a very Republican household. I was taught that Republicans were good guys, like John Wayne, Apple Pie, and hot dogs. I was taught that one of the reasons why Republicans are good guys is because they believe in small government. So I guess I'm asking today, why am I here? President Passidomo's bill is not needed. We have good laws in order for foreclosure. What is happening with these good laws is they're not being enforced. On this bill, it seems the Democrats are standing up for small government and are protecting the people. So if you vote yes for this bill, what are you getting? You're getting an unconstitutional law. It's taking away the homeowner's due process and equal protection. This bill wants to have show cause hearings, which homeowners need to prove why these cases should be not be brought against them, shifting the existing way we do things, where the bank should have their paperwork in order and prove why they should be allowed to foreclose. And this is going against years of how we've been doing things, and it violates how we do our contract laws. This bill shows a bias against the homeowners with provisions that homeowners need to pay while the case is going on or leave the premises during the case, not considering whether or not the correct entity is suing, which is often not the correct entity suing. This bill allows for hearings to take places in judge chambers outside of public view. This, again, it violates due process. I personally have seen the difference of what witnesses in a court hearing changes the behavior of the judge's ruling. So I don't appreciate that provision at all. So today I'm asking you to remember who you represent. You're representing the people of your districts. And I'm asking you to vote no on this law.
So we appreciate that. Next, we're going to hear from Diane Ferguson.
Community advocacy network ways and support.
Thank you, Ms. Ferguson. Alice Vickers. Ms. Vickers, would you approach? She's representing Florida Consumer Action Network.
Thank you, Jimette. My name is Alice Vickers with Florida Consumer Action Network. First, I do want to thank Representative Passidomo. I know that this is an issue that is very important to her. She has worked very hard for the past 2 years on this legislation. Her door has been open. She has listened to all of us harangue her endlessly about this bill. I know that her heart is in the right place on this bill. Unfortunately, we cannot support her on this particular piece of legislation, however. I don't want to reiterate what's already been said. I think most of the points have been raised. I do want to point out a piece that Representative Waldman was asking about. Under current law, the show cause language is that if a defendant files defenses by a motion, a verified or sworn answer at or before the hearing, such action constitutes cause and precludes the entry of a final judgment at the hearing to show cause. Current law is that if you raise a motion, verified answer, sworn answer, really, if you present any paper to the court, your case is going to be kicked out of the show cause process. What this bill would do is say that if the defendant files verified answer, affidavits, other papers, presents evidence at or before the hearing, which would be sufficient to preclude entry of a summary judgment. This is the issue that is of concern to so many of us, because in most cases you would not have had the opportunity to engage in discovery. Finally, I just want to reiterate that a lot of our concern here is what Mr. Fields just stated, and that is, we know there is a lot of fraud and abuse that has gone on. The largest consumer settlement in our nation's history was by the 49 attorney generals, and that was based on over 2 years of investigation as to robo-signing that has occurred in the foreclosures. Office of the Comptroller of the Currency has just inked their own settlement against about 10 banks. That as well is based on abuses in foreclosure. That is why we are so concerned. We share Mr. Fields' concerns. We share Representative Passidomo's concerns. We just think this is the wrong way to address the problem. Thank you.
Thank you, Ms. Vickers. Next, we'll hear from Pete Dunbar, representing the Real Property Probate and Trust Law section of the Encore.
Thank you, Mr. Chairman, and I will try to do this briefly because we had the opportunity to discuss this a couple of weeks ago. I would observe before I begin, however, that there is a note of interest to me that I see both the Florida Bankers Association and then Ms. Vickers and Ms. Newton opposing the bill and wanting to preserve current law. This is a most complicated area with many people to blame, and I think that Representative Passidomo has done a good job to step up and try to address it. And I think there is a particular emphasis with the consumer protections that she has provided in the bill. Let me touch on them briefly. One, Representative Walton, I absolutely agree with you, and that same issue I believe was raised by Representative Rodriguez. It is now easier for someone to come in and stop the process. Show cause already exists. The standard is already summary judgment standard, but it has to be done through a lawyer or some sworn complaint. In the case of the anecdotal problems that Ms. Cornell and her clients have is with the current process. Now it is easier to access it and stop that process. It was interesting to me that Mr. Gillis said there's widespread fraud, and we have all acknowledged that's the case. Representative Passidomo has tried to address that to make sure that we are requiring at the front end that the bank prove up their case with the appropriate documents before they start down this path. So easier to defend by not even requiring any longer a lawyer. You could have written out in hand those other written papers, as Representative Waldman pointed out, and that would have gone to the court without the necessity of a formal motion or a filed affidavit. There's some fairness for other consumers here as well, and I know a couple of people have weighed in support of it. Mr. Gillis rightly pointed out that the process could work quickly, but the banks get to sort of through the process and don't conclude it. That leaves the associations that are insuring, particularly in condominiums, the assets of the bank at the expense of the unit owners who are paying on time. And Representative Passidomo has recognized that, so with their standing, they can take the process to finality, and the banks then will be paying their proportionate share of assessments so that the insurance costs, the maintenance costs, they are contributing to for the asset they have. The fairness to the consumers here are for those that are paying their bills on time and are currently carrying somebody else's burden because the process doesn't go to completion. I appreciate Ms. Newton's comment about the finality of this, and Mr. Fields also addressed it, but really, do we want to take, as Representative Rodriguez pointed out, those people that have made their home or their family in this home and be used as leverage with no termination for 20 years or 50 years that the threat may be to return, that somebody is going to try to take that home from them? A bona fide third-party purchaser of these properties should be able to have their home, make it their home, and not be used as leverage by someone who had the full opportunity for a circuit court proceeding with all of their due process rights, all of the ability to appeal. Finality for them is protecting that consumer and that family from the home that they acquired. Mr. Chairman, if there are questions, I'd be happy to address them, but I think Representative Passidomo has done a good job trying to balance and address the problems with the current system. We should not let it stand, and I think she's off to a good start. I hope you will support it.
Thank you very much, Mr. Dunbar. Next, we'll hear from Sylvia Landis. She's representing herself. Good morning, Ms. Landis.
Good morning. Thank you, representatives. All legislation should support Floridians and make our citizens, communities, and states stronger. But unfortunately, this legislation does not. I believe the intention from Representative Passidomo was well intended. But I would like to introduce into evidence a from the Dean of Florida Civil Law that was submitted in last year's foreclosure hearings. And Henry Trawick is the author of Trawick's Florida Practice and Procedure. The letter that I'd like to introduce opposes the legislation and lays out a lot of concerns that came with last year's legislation. We will replace the letter in evidence with an up-to-date analysis of the law in the coming days. So we should have that by Monday. One of the arguments has been that we need faster foreclosures. Also, last session I heard that we need to address the need for vacant and deteriorating properties in our communities. Both of those are real concerns, and I'd like to address them. With the faster foreclosures, I want to remind everyone that the rule of evidence for summary judgments is that there must not be any issue of material fact outstanding. And the problem is with a lot of foreclosure cases that we have facts. The reality is that 95% of the foreclosure cases are undefended. Most of the homeowners out there are so overwhelmed, they don't even come to court. I'm from Hillsborough County. I've gone into the courts and watched, and most of the homeowners don't even show up. So we're really, this is a broader issue. In terms of the information, I would like to ask each of the representatives, I'm sure all of you are living in your own home, or certainly have been a homeowner at some point. I would like you to go back and look at your own mortgage in the records, in the county clerk's records. And 90% of the mortgages now are owned by Fannie or Freddie. And I want you to look and see whether Fannie or Freddie is listed in your county clerk records for your mortgage. And then I want you also to go to the Fannie or Freddie site and run your name or your address. And you will find that they don't match. And you're going to learn, as someone who is paying your mortgage, that this title problem extends to all of us. It's a big problem. These records at the county level are not accurate. Why are they not accurate? Because there has been systemic fraud. And the property records, there is nothing that stops the fraudulent forged records from entering the property system and then being used in the court cases. The courts are overwhelmed. The homeowners are overwhelmed. If you're a homeowner and there are fraudulent records, unless you can afford to hire an attorney and a document expert, you can't look at a document, as I have, that says that X person, I'll use the name Y, who was in the 60 Minutes program, who was
Sorry, man, we start to wrap it up based on time.
And so you simply don't have the resources to defend. In terms of vacant properties, I want to mention something important. In Palm Beach County, there was a study that found that 10,000 properties had not gone from summary judgment to auction over a year later. Why did this happen? Obviously, the banks had the documentation and the approval from the judge to get them to summary judgment. The reason they didn't is because at the time the title changes, you have to pay homeowner fees, you have to comply with local ordinances to maintain the property. You also have to show the losses on the bank books. So this is why we have community problems. It's the banks that are causing this, not the homeowners. Thank you.
Thank you, Ms. Landis. Next we'll hear from W. Theodore O'Connor, representing the Attorney's Title Fund Services.
Wait and support, Mr. Chairman.
Thank you, Mr. O'Connor. And next we'll hear from Jean Baga, representing Focus of Orlando. Good morning, Ms. Baga.
Good morning, everyone. My name is Jean Baga. I'm here with a personal story. I did become a volunteer with Focus of Orlando to help homeowners who experience the same thing that I did. I also believe that I do believe her heart is in the right place, but I do stand in opposition to the bill. I do want to thank the lawyers of our state who work with homeowners pro bono, because that is where the true issue lies. Our homeowners don't know how to defend themselves in court, and I'm going to tell you what happened to me in the court. My husband and I suffered hardship, and we approached our bank. I don't like to bash the bank, so I'm not going to mention their name, but the initials are WF. The biggest issue that we faced was being rejected over and over again by the bank for our plea to have modification. We had income, it was reduced. They kept rejecting us, I kept saying, why? If there's a program out there to help homeowners that can keep paying but want to reduce payment, and you're rejecting me, then who are you helping? I continued to ask question after question. Went into this process not knowing it was going to take 2 years. I had 5 pages in Excel of documentation using 10 fonts of the atrocities of their responses to me. I started taking down every person from the bank. I started taking down their employee number and their name and documenting all their responses. At one point they said our investor doesn't participate. Who is our investor? I don't know. At one point they put us in the system and we had to agree to automatic payments withdrawn from our bank. We agreed. I checked, the payment went out on a Friday. I called the bank on a Monday to confirm, and they said, oh, you've been thrown out of the program. Set it up again, it happened the second time. They took the money, then they threw us out of the program. So we went to court on my own accord without a lawyer, filed a motion for our court right to mediation. So we went to the mediation, which was run by, I believe it was a retired judge brought back into Orange County. And this judge was sitting there, and the bank rep walks in, gives us his name, I wrote his name down. He said he didn't have authority, but he needed to get somebody on the phone from the bank who had authority to make decisions in this case. He gets him on the phone, I took down his name and phone number. When it was over, it was agreed that they would modify us because the man with authority on the phone said we should qualify for a modification. There's nothing in our records that says otherwise. So I called back 2 days later to talk to that man. He didn't exist. You never heard of him. In the end, we fought, and the judge that did our mediation told me, take this to the highest level in society because you guys have got your ducks in a row. And we did, but we had to get a lawyer. I had to pay money for the lawyer, but in the end, we won. And I'm thankful for that, and I know homeowners can't afford the liberty of a lawyer. So I really need those who work pro bono. But that is where the issue lies. The homeowners need help. And I am very concerned about the ones that have already been evicted. They don't know where to turn. I have a homeowner, and I'm going to wrap it up. Homeowner that came to me for help because he knows I'm helping people in my community, and I'm the liaison, sending them to people I know will help. Joel Rosales, he bought a house with his kids. His income was reduced. He wasn't unemployed. Again, he didn't get a modification. He could make payments, but he couldn't get a modification. He went to 3 different agencies for help to the tune of $15,000, and they were all taking his money, and they were scams. He's out of his home. He lost $15,000, and he has nobody to turn to. We are trying to help him in Orange County with attorneys that will help. So this bill, I think it has good points and bad points, but we really need to look at what our homeowners need. They need representation when they go into court. They don't know. I knew because I did my homework and I spent 8 hours a day on this. But we really need to look at what the homeowners need, and it's legal help that they can't afford. Thank you for your time.
Ms. Beck, thank you very much for your presentation. Next we'll hear from James Rusick from Old Republic National Title Insurance Company.
Thank you, Mr. Chairman. I waive in support.
Thank you, sir. And next we'll hear from Jerry Neely from Pastors on Patrol. Reverend? Good morning, Reverend.
I'm glad you said good morning, and I'll say it is.
Yes, sir.
It's not because I'm the judge. But as legislators, you are. And the composer of this bill, who has advocated that the judges are responsible to make calls and so forth. Then I'm here today, and hopefully just to, in the interest of the greater good. I'm a member of Pastors on Patrol, which is an organization of clergy and affiliated churches, about 80. Our president is Dr. W. James Favor, who is the former National Vice President of the Southeastern region, which he represented 400 churches of the Progressive National Baptist Convention, pastors in the city of Tampa, Florida. This thing is going out. I'm moving into the 20th century. thank you for your patience. And I would like to just read this into the record and just encourage you, as you more than likely already are, just working toward the best ends as we all see. And so, pastors on patrol would like to have the privilege of weighing in with this resolution in opposition to House Bill 87 of the state of Florida. Whereas House Bill 87 is contrary to the existing federal position, contrary to the existing federal prohibition of dual tracking and as amended, as provided through Dodd-Frank legislation, and whereas House Bill 87 is contrary and in violation of the citizens' right to due process by circumventing and preventing the procedural progression of foreclosure cases within the court system, specifically through prohibiting state constitutional officers, including the clerk of courts as the registrar of deeds, from carrying out their assigned constitutional duties and oaths of offices, because its provision allow and permit robo-signed and fraudulently forged documents to be authenticated by others who are not bound by sworn obligations that are also enumerated with the 50 states Attorney General's agreement. And whereas these and other numerous instances, as verified by a myriad of witnesses, calls into question the moral consistency of equitable justice under the reign of the sovereign of the universe. So, therefore be it resolved that the faith communities with which we are affiliated do herewith affirm, advise, and strongly recommend the renunciation, I don't know if that word being there, of House Bill, I think renunciation is wrong, House Bill 87, done this 7th day of February 2013, President, so forth.
Appreciate your being here.
Thank you, and we're praying that matters will be able to do and all that you have to do.
Thank you, sir.
Thank you.
Our next presenter will be Joe Adams, representing the organization known as Call, and also Veteran Public. Good morning, Mr. Adams.
Good morning, Mr. Chairman, Mr. Committee members. I speak today as an attorney who practiced real estate law for 26 years in Fort Myers, Florida. I also come as an emeritus chairman of the Florida Advisory Council on Condominiums, having had the privilege of being appointed to that council by this House of Representatives. My primary practice is representing condominium and homeowner associations, and I come today to speak in support of the bill primarily from that perspective. Florida has 22,000 condominium associations, 16,000 homeowner associations, almost 40,000 associations. Several million Floridians reside in mandatory membership associations, how all real estate is developed today. And a fundamental tenet of living in an association is when things cost $100, there's 100 people, they all pay $1. If only 50 are paying, the 50 that are left pay $2. And having lived and raised my family in Fort Myers. I had the interesting experience of living at ground zero of the real estate meltdown. If you read the papers, you would see that Fort Myers, Cape Coral tied places like Los Angeles and Las Vegas for the number of foreclosures filed each month, not per capita, but in gross. And we're not here today to talk about whether the banks committed fraud. Of course they did. They all admitted to it or didn't admit to it, but paid billions of dollars. And the money from that is being put into programs to help people in need. There are certainly people in need. But in places like Fort Myers, non-urban areas of Florida, our entire economy is based on real estate and tourism, and people wanting to come there and live there because it's a nice place to be. And the uncertainty that exists in this market due to the foreclosure crisis has really turned that on its head, and we really need to get past that. And I believe that this bill does that. There was a lot of discussion about the order to show cause and all of that, and I think as Representative Waldman pointed out, and as Mr. Dunbar alluded to, the standards are easier. You used to have to file a verified or sworn answer. It's on line 268. Now you have to file a paper. In the law, a paper can be a post-it note saying, I don't think this is the right thing. And so all of the talk about this being more onerous on homeowners is really, in my view, incorrect. There was a lot said by several people, why aren't the banks taking title when they hold summary judgment? The answer is easy. They don't want to own units in condominium and homeowner associations. They don't want to pay the fees. They want to be protected by what's called a safe harbor cap, which is 12 months of investment, so they sit on it until they can short sell it. And this is causing tremendous burden. Citizens Insurance is trying to depopulate condominiums. I've had clients who's told me in the last week their insurance is going up 200 and 300%. And at some point there's a breaking point. Where we need to be is to get past this. The prices will adjust as the market adjusts them. But we need to get people who are staying in units 3, 4, 5 years and not paying anybody anything. We need to get past that. We need to get past banks who sit on foreclosures for 3, 4, 5 years. And this bill, in the order to show cause, allows a junior lien holder, which would be a condominium or a homeowner association, to make a motion to the court to let's get this thing done. Let's sell it on the courthouse steps. Let somebody buy it for what it's worth. Let's get a paying customer in for the association. Let's get the distressed real estate out of our inventory. And I think that this is a very important step forward in doing that. Thank you.
Thank you very much, Mr. Adams. We have, I think, concluded our public input on this measure, members. So we're ready to move into debate. I'd like to have a show of hands for those who intend to debate this bill, so we get a list going. Make sure we don't leave anyone out. Okay, so take that down, and then indicate your interest here. We've got all the indications written down now, so with that, we'll go ahead and begin. Representative Stafford, would you like to begin? I recognize you. Okay.
Thank you, Mr. Chair, and Representative Passidomo, thank you for your presentation, and all of the individuals that have come to testify today. I believe this bill addresses a short-term problem with a long-term loss. The foreclosure crisis will end, but this law will still be on the books. One of the speakers has said this bill appears to diminish the rights of consumers while attempting to streamline the process, and I agree. This bill is problematic. My concerns include the show cause provision that has already been discussed. There are due process and equal protection concerns with this bill. There's also, I have concerns with the reliance on possibly questionable paperwork or documentation. among other things. I don't see how this bill protects homeowners who have done the right thing, who have been victims of fraud and other unscrupulous activities. I don't think this is good for Florida, and so I will not be supporting this bill today. Thank you.
Thank you, Mr. Stafford. Representative Spano in debate.
Thank you, Mr. Chairman. I want to thank Representative Passidomo. Thank you so much for your genuine concern about and attempt to address the foreclosure issue we face here in Florida. I also want to thank you for your patience with me as we discuss this bill. And I do intend to vote yes for the bill today. I look forward to working with you, Representative Passidomo, and in order to try and address the concerns which hinge primarily, in my respect, on due process rights. And I look forward to finding a way to address the concerns of all the parties involved, but hopefully without jeopardizing those individual due process rights. And this is just a matter of what I believe to be the most important thing, that's funding, appropriate funding for our courts. That's the most critical issue, in my opinion. So, I do appreciate you, and thank you for your.
Thank you. Representative Waldman in debate.
Thank you, Mr. Chair. Thank you also, Representative Passidomo. I appreciate the time you've given to me to speak to me and to work with you on this. In fact, last year I voted for a similar bill on the floor of the House. I want to vote for this bill because I think you're doing the right thing and you're trying to move this process forward. I have real concerns about changing the standard of review for a show cause hearing. And it's consistent really with what Representative Stafford just said. We're changing really the nature of a show cause hearing. And I think that if somebody shows up in court, I don't think that they necessarily should meet that standard of summary judgment. Because, quite frankly, they're in many instances not lawyers. And they don't know. I don't have an issue with with what we talked about regarding finality. I think that provision is great. I like that. I like shortening the statute of limitations for petitions. I think you have some really great features in this bill, and I have a feeling that by the time it gets to the floor, I'll vote for it. But today, I can't support it because I think it still needs some work. I see how Representative Spano, he goes the opposite way. He's ready, even though he wants to work on it, he'll vote yes today. I go the opposite way. I think that we can work on it together, even with a no vote at this time, and we can take into account all of the interests that everybody else has. I do think we also need to talk in terms of a provision in your bill which would require foreclosure sales to go forward much quicker. Because what I've heard is in many instances, foreclosure sales are the problem. And that's where everything just continues to get delayed. I believe once something's happening in the process, then we really ought to take the proper action. So at this point, I'm going to vote no. I appreciate all the time you spent with me, and I feel very confident by the time we get to the floor when we work out the issues.
Thank you. Representative Boyd in debate.
Thank you, Mr. Chair. I'll be very brief, but I intend to support this today, and I'd like to help get it to the floor so my friend Representative Waldman will have the chance to debate it and discuss it on the floor. It's a very tough and complicated issue. I applaud you for taking it on. There's a lot of challenges, but everyone that's testified today has said you've been open to dialogue and discussion about improving it. I know you will do that. I know you'll continue to improve it as we move toward the floor. I too have come to you with a couple of questions. You've been open to those concerns as well. So I'd like to support it today to move it on so we can make it the best bill possible so it gets to the floor and we have that full debate. Thank you, Mr. Chair.
Thank you. And now we'll recognize Representative Rodriguez in debate.
Thank you, Mr. Chair. And since everybody's explaining how they're going to vote now and later on, I just want to echo my comments in my opening question and just saying that my intention, like Representative Waldman, is to get to a yes. I think we're more than 80% of the way there. I really appreciate the work you're doing, and I'm voting no only today on the same concerns that Representative Waldman has. related to due process. But again, I'm doing so with the intention that we're working toward all voting yes on the floor. Thank you.
Any other members in debate? Seeing none, then the debate is closed, and Representative Passidomo, you're recognized to close on your bill.
Thank you, Mr. Chair. Thank you, members, for your indulgence in listening to a 2-hour presentation. I had a very impassioned closing, but Mr. Dunbar and Mr. Adams moved into my office and stole it. But I would like to point something out that I think we need to realize, and that is that the relationship between the borrowers and the lenders that begins way before it reaches a foreclosure is something that the state of Florida does not regulate. The relationship between the borrower and a lender is regulated by the federal government. The federal government regulates the banks. We do not interfere in that contractual relationship. If we were able to, we probably wouldn't be here because Florida, unlike the federal government, gets things right. So this is the problem. The fraud, and many of the complaints that we have relate to that relationship that occurs before the state of Florida intervenes. We intervene, if you will, when a foreclosure is filed. That is governed by the state of Florida and managed by the courts. And so what the intent of this bill is to create a scenario that no matter what happened before, it's going to be done right when the state of Florida becomes involved. And so we start with the complaint. It's got to be done right. As I indicated earlier, we're telling the lenders, don't bother filing the complaint unless you've got it right. You've got all the parts there. You can show you're entitled to foreclose. So the courts can look at it and move the process forward. I can talk about many of the comments that were made, but our time is short. I ask for your favorable vote today.
Thank you, Representative Passidomo. And with that, will the administrative assistant please call the roll on House Bill 87?
Representatives Boyd?
Yes.
Lyman?
Yes.
Davis?
Yes.
Goodson?
Yes.
Hager?
Yes.
Oliva?
Yes.
Passidomo?
Yes.
Rodriguez?
No.
Spana?
Yes.
Stafford?
No.
Stone?
Yes.
Waldman?
No.
Chairman?
Yes. And with that, the bill is reported favorably. Congratulations. Okay, members, we're at the point now where we're going to take a brief recess. As I mentioned earlier, we'll shoot for a 5-minute recess and we'll be back in here at number 10:10. Thank you.